I wrote a press release, a phony press release that said prominent Houston lawyer opens New York office, selects Rick Meadow as managing attorney. And then I had a whole written press release with quotes from mutual friends, obviously made up, but I quoted mutual friends of ours, an expert, another lawyer, all that. And then I had a script for a press conference, phony press conference, why New York, why Rick Meadow, why now? And then my resume, and I sent it all to Mark on a Friday. He got it on Monday. We spoke on Monday, and he said, "What are you doing on Wednesday?" I'm like, "What do you want me to do?" He said, "Meet me at my New York office." "What New York office?" He goes, "BJ's restaurant."
Welcome to the Heart of Law podcast. My name is Marina Omizai, and I'm your host. Our guest today has spent more than 4 decades on the front lines of American mass tort litigation. Rick Meadow has tried over 25 cases to verdict, settled claims for clients in the hundreds of millions of dollars, and was central to the Lanier trial lawyer firm behind the record-setting Vioxx verdicts. In 2008, he testified before the United States Congress on the Sunshine in Litigation Act. In 2004, he opened and built the Lanier Law Firm's New York office from the ground up. He went on to serve as the firm's national mass tort leader, and in 2023, he founded the Meadow Law Firm in Phoenix, one of the first plaintiff-sided practices in the country to operate as an Arizona alternative business structure. His daughter Ruby recently joined the firm and is preparing for law school. Rick, welcome to the Heart of Law. How are you?
I'm great, Marina. Thank you for having me. This has been a long time coming.
It's been a long time coming. I started this podcast during COVID, and I've been wanting you to be a guest on this podcast, but a lot of transition and changes were happening. And I think the timing is actually perfect because you have
hmm
a lot to share, and a lot has happened in the last 5 years.
That's an understatement. Yep.
Well, let's get started because you have such an interesting background and you have such an interesting life. And before you went to law school, before you became a lawyer, you were thinking about maybe going to culinary school. You were thinking about working in the restaurant nightlife world. You were a comedy writer. So you've lived a lot of different lives before you actually became a lawyer. Tell me about that.
Sure. I went to college at Rutgers, and I probably would have benefited from a gap year before going to college. But, growing up in a traditional household, you go to high school, you graduate, you go to college. I didn't see any options for me. So I go to Rutgers, and one of my closest friends, his dad owned a restaurant right near campus. And I started tending bar my sophomore year, fell in love with the restaurant business, started working full time at the restaurant while I was in college. And after my junior year, decided that was going to be my career. So I quit college for a couple of years. I was tending bar, I was waiting tables, and as a 20-year-old or 21-year-old making what I thought was incredible money, I'm like, this is it. And, I learned how to cook, and I really liked being back in the kitchen, and thought about culinary school. And then one night I was behind the bar after a couple of years of tending bar after I quit college, and somebody yelled to me, "Hey, Chief." And I just went, I can't take this anymore. I'm too smart to be doing this.
Somebody's
So I looked at law school bulletins that I had, and there was only one school that had a June 15th deadline back in 1981. And I went, I'm going to send it out there. So I sent it out to California Western in San Diego. It was the only school I applied to. And I got in, and the rest is what they say, history.
great. Yeah. Do you still cook?
Yes, not as much as I used to, but now that my daughter's living with me, she does all the cooking. She's a better cook than me.
Well, cooking is a passion of mine, and I think there's something therapeutic about being in the kitchen. I love going out to dinner, and a lot of our deepest conversations have been over dinner over the
Without a
years.
doubt.
figuring out which restaurant we're going to go to when we meet. So I love that. Does Phoenix have a good food scene now?
It does. It's surprisingly, well, maybe not surprisingly, because
Yeah.
it's a vacation destination. So there's a lot of really good restaurants,
Yeah.
good resorts, good restaurants, good golf, obviously.
Yeah.
Hot summers, but you don't shovel sunshine. So I don't really mind the hot summers. I got tired of the cold winters. So
Oh,
this was my trade-off.
yeah, no, it's quite the transition. And I want to get into it, Rick, because again, like I said when we first just started this conversation, a lot has happened in the last 5 years. You spent decades helping architect what I think is one of the most successful plaintiff firms in the country, the Lanier Firm. And when you look back now, I'm curious to know what part of your identity was built there? Of course, you worked for some other firms before, you had some experience before you joined the Lanier firm, and you were there for a long time. But what part of yourself do you think was quietly waiting to emerge outside of it? In other words, was there a moment where you realized that staying and growing were no longer the same thing?
Great question. And let me set it up this way. I have been doing insurance defense as well as plaintiff med mal for a number of years. And then in the 90s, a friend of mine opened Fred Barron's New York office of Barron and Budd. And I had tried cases with her before, and she said, we could really use a trial attorney. Why don't you come over and, you can get involved in asbestos litigation. So I went over to Barron and Budd, and I was one of the trial lawyers there for a few years until Fred Barron closed the New York office of Barron and Budd. After that point, I went to Whites in Luxembourg and was one of the senior asbestos trial lawyers there.
Yeah.
And I was there for a number of years until a friend of mine moved down to Houston to work with Mark Lanier. And I had seen Mark speak at seminars, and he was by far the best speaker I had seen, the most clever, just, well, you've seen him speak, he's a force. So I emailed my friend and said, hey, what's it like working with Lanier? He said, it's great. Why don't you come down here? I'm like, no, I want him to open a New York office. And he said, well, he's been talking about that for a while. You should call him. And I'm like, well, it's great that he wants to open a New York office. What am I going to do? Call him, say, hey, this is Rick Meadow. You want to open an office with me? I didn't think that was going to fly. So what I did was I wrote a press release, a phony press release that said prominent Houston lawyer opens New York office, selects Rick Meadow as managing attorney. And then I had a whole written press release with quotes from mutual friends, obviously made up, but I quoted mutual friends of ours, an expert, another lawyer, all that. And then I had a script for a press conference, phony press conference, why New York, why Rick Meadow, why now? And then my resume, and I sent it all to Mark on a Friday. He got it on Monday. We spoke on Monday, and he said, what are you doing on Wednesday? I'm like, what do you want me to do? He said, meet me at my New York office. What New York office? He goes, BJ's restaurant. So I
Oh,
met
wow.
Mark at BJ's restaurant, and we ended up having like a 3 hour lunch, which, if you know Mark, is unheard of.
Yeah.
Mark's meals are usually 20 minutes and out if it's ideal for him. So, we really hit it off. And then he said, I want to do it with you. So we opened in 2004, right before Vioxx was pulled off the market. And when I joined Mark, he didn't have a pharmaceutical department. There was not a mass tort department. He was doing asbestos and commercial litigation and some other things. But we opened the pharmaceutical division, with our first case was Vioxx. Then Vioxx got withdrawn. And then from that point on, we just, skyrocketed. I opened it with Evan Janish, who you know. I brought Evan over with me from White's. It was Evan and myself as the lawyers. And we went from 2 lawyers to about 16, from 1 floor to 3 floors within 3 or 4 years. We had 7 cases when we opened, and 3 years later we had 7,000. So, I look at my career as kind of like pre-mark, post-mark, or,
Yeah.
and we grew the firm into, Mark was a Texas lawyer, extremely accomplished, but was regional. And then with the addition of the New York office, we became national. And I think we were the only Texas firm to open a New York office that's still, a vibrant office.
Yeah.
So that was a transition in my career where, I ran the office and grew the office. And, it's made easy when you're doing it with somebody like Mark, with his reputation and his skills. But I have a set of skills that were great for the office. And, I'm still of counsel there. We built up the practice, from 15 lawyers to 60 something. Pharmaceutical litigation became our main revenue generator. So it was pivotal for me joining Mark.
Yeah. How long were you there?
Well, I'm still kind of there. I'm of
Yeah.
counsel full time until we opened Meadow, till I opened Meadow in January of 23, I think it was.
Yeah.
Um, I had considered a retirement or, we when we decided to do Arizona, I had gone into Mark's office and I said, "How much longer do you think you're going to practice?" And Rachel Lanier had just joined the firm, and he said, "I don't know, probably a good 10 years." I'm like, "Well, you won't have me for 10 years. I'm not going to stay that long." He goes, "Oh, come on." I'm like, "No, I got to figure out, a way that to ease into retirement or vacation." So that's when Arizona had just passed the ABS rules.
Yeah.
So we took a look at those. I'm like, wow, we could do the Meadow Law Firm, get funding, and not only represent people here in Arizona, but be able to refer cases into Lanier. So that was the original thought process of the Meadow Law Firm. Since
Yeah.
that time, we've grown into our own. We litigate in-house some cases. We're still a major referrer for Lanier and some other law firms, but we've taken advantage of the new laws to grow a really viable and vibrant law firm.
Well, I can't wait to get into all of the things you mentioned because they're all like big topics, right? The ABS, financing, what's going on in mass torts, etc. But I guess just to kind of put a pin on sort of the discussion where you're talking about retiring and leaving, easing out, what seems that's happened is you have started over, right?
Yeah,
It's
that's
it's
that's a
it's a
good
new
analogy.
it's a new beginning. So, what is that something? Was there a vision there? Was there something that you thought? Because honestly, starting over in a sense, later in life, psychologically, it's fascinating to me because the stakes are higher, but the clarity is deeper. And so I'm curious to know, did building your own firm feel liberating, or you got all that like excited, inspired, this new sort of rush of ideas and energy, or was it terrifying and you did it because you knew you had kids that maybe, you want them to come into the business? So I want to dig a little deeper into why you decided to do this.
Uh, Originally, when I decided to do it, I looked at it as almost a part-time job. I was going to take advantage of the rules out here, open the Meadow Law Firm, be a referral firm in addition to, representing people here in Arizona. As after we got our funding and we started to grow and get cases, then my daughter started expressing an interest, and I'm like, wow, we can build a legacy firm. So my partner, Kyle Nenninger, and myself decided to dedicate the firm to our kids. Kyle's daughter's going to be entering her third year of law school. Ruby is my daughter, who is studying for the law board. She's working at the firm and is really loving it and decided this is her calling. So to watch the excitement grow in her and the potential for her to, take over the firm and, continue the Meadow name got really,
It's reinvigorating.
it really was.
Yeah.
I actually sold my house, moved closer to the office. I sold my house that was in Desert Mountain, which was a resort, basically 7 golf courses and all that. Now I'm living right near the office and I'm more excited than I was when I was living on a golf course. So, it's a combination of
Yeah.
having my name on the door, being the one who grows the law firm, and now my daughter coming in, and my son is going to come work for us after he graduates high school as well. So it's becoming a family firm and a legacy firm as well.
Yeah, I love that. I love that for you. So, as you do this, obviously you've learned so much from so many firms. Are there things that you're taking from your past and repurposing in this firm, or are there or are there things that you're staying away from? In other words, how are you designing your firm differently from what you've seen in the past?
With 40 years of experience,
Yeah.
I've seen a lot. I've seen a lot of firms fail or a lot of lawyers leave very, very prestigious firms because, they weren't acknowledged or treated right. So my goal when opening it was to try and learn from all those, mistakes or all those observations I made over the years. Only working with people who I really like and admire and respect. When you're first growing a practice, like early on, you might do cases or work with people that you wouldn't towards the tail end of your career.
Yeah.
So I know, over the years, who are the lawyers that I want to work with? Who are the vendors who I want to work with? What type of cases I want to get into. I'm able to focus on that and do it the way I want to do it. Not, I have my own agenda, not somebody else's agenda.
Yeah. And obviously you said this, but so there is no conflict since you're of counsel to Lanier. There is no conflict of competition or anything like that. I mean, I don't think Mark Lanier is worried about competition.
No.
But you know what I'm saying? I think you're setting up a business that is, seeking out a lot of the cases that he likes and works. And then you've created this partnership. And I assume, was there any tension leading to that, or was it an easy transition for the both of you? I'm just curious to know how this all
There was
unfolded.
zero tension. When Mark spends like the month of August a lot in England, and he came back 2 years ago and said, I've been thinking a lot. He goes, because we had talked about my retirement or, whatever. And he said, there's no reason why we can't do the Meadow Law Firm in Arizona, the Lanier Law Firm here. And, you stay active, refer cases, we still work together. So there was zero tension, 100% support from Mark, who continues to, to be 100% behind the firm. When we were going for our funding, Mark zoomed in for like an hour and a half with the funder. So yeah, there was zero tension. He's still, a close friend of mine, and we still do cases together. So that there's been no
Yeah.
backlash or no hard feelings or anything like that.
What are some things that you're sending to Mark right now? Like what kind of projects are projects?
Whatever mass tort he might be interested in, whether it's a barred power port or Roblox extortion. He's now looking at Olympus scopes. Whatever he might be interested in, I'll talk to him about it. And, I'll decide if, we want to invest money in the marketing for those cases, whether we want to do some of them in-house, and send the others out.
Yeah.
So, I speak to either Mark or Kevin Roberts, who's his brother-in-law, who's taken over my position there. What litigations are you interested in?
Mhm.
How many cases do you want? What's your criteria? So we continue to work closely.
Yeah. Now, is this in the sense, because a lot of people want to refer cases to the Lanier firm, given the trial lawyer skills that he has. Can anyone send him cases, or is he very specific about who he works with, who he gets cases from?
When I was there, we had our friends of the firm who were the referral sources that we would turn to, like, we're doing this litigation, get us cases. There are a lot of firms or marketers out there who would love to send more cases, but you got to be careful who you accept cases from, where they're coming from. So that was my job when I was there, to make sure it was a valid source, it was a good firm or a good marketer sending us the cases. Mark just doesn't accept cases from anybody.
Yeah.
It's his reputation on the line when he gets the cases and they litigate them. So you
Yeah.
want quality cases from quality firms or quality marketers. You don't want to be associated with the bad ones.
Yeah, for sure. Yeah, I'm sure people are thinking this, right? There's a lot of attorneys that come into these cases, and why send it anywhere else when you can send it to Mark Lanier, and he would settle it for the most amount of money. But to your point, he doesn't just answer the phone call to everybody, especially people he doesn't know.
Yeah.
So having that close relationship to him makes the difference, right? In terms of how you work with him and
Sure. And I
and
kind of know, what he's looking for in cases,
right. You know his
what makes the
style.
difference. Having stewarded that ship for 20 years,
Yeah.
give or take, with Mark as my co-captain, so to speak.
Yeah.
We were pretty good at choosing cases or staying out of cases. It's the art of picking cases is the other side of the coin of not getting involved with all the litigations that are out there.
Yeah,
So you
for
have to be,
sure.
you have to be picky, choosy on which
Yeah.
cases you get involved in.
Yeah. You openly talk about funding and the ABS, and not everybody does that. I think a lot of lawyers, especially lawyers who, have done things the traditional way for a long time, tend to look at those avenues with this suspicious lens. You know, there's a lot of stigma associated with litigation finance. And then the ABS, is this experiment, a national experiment. From your vantage point, what are people getting wrong about the conversation of the ABS and funding?
Great question. Great question. The original purpose behind the ABS change here in Arizona was to provide legal services to those, who normally wouldn't get them. It was almost like an outreach. The Supreme Court got rid of non-lawyer ownership or non-lawyer referrals to be able to offer legal services to a broader range of the population here in Arizona. The advantage for the lawyers is a lot of the finance is non-recourse. So your ABS funder is a partner with you. I try to pick litigations that are going to benefit the most people, where I think some of the problem comes in where people think you get litigation funding and they're running the cases. They're making the decisions. That's not the case at all. I pick the cases, I run the cases, I make the strategy decisions. I do all of that. It's just the ABS has allowed me to reach a broader population, has allowed me to staff my office, has allowed me to go into areas that traditionally I would not be able to go into because I didn't want to risk my own funds. But, litigation finance or funders are willing to back projects that I don't want to say are risky, but can do a lot of good, but do have the risk. So I think it's opened the landscape for me to be able to do more cases and help more people. I think that the misconception is, there's an unlimited amount of funds for an unlimited amount of law firms. And that's what's scaring some people away is the amount of money coming in, which is going to be regulated. It's starting to be regulated already. And I think people have the misconception that the funders are the ones making the decision when to settle, what the number is. If a law firm's doing that, then they're committing malpractice, and that's a conflict. But we're not doing that.
So you have an Arizona firm, so you can partner with non-lawyers. Are you partnered with capital? Are you partnered with marketing, with both? How
The partner, our funders, we're partnered with them, the funders, not
Okay.
the marketing companies.
Okay.
That's normal practice. I don't
Yeah.
have any marketers who have a back end interest in the cases. They're just our marketers.
Okay.
They're the back end ones I haven't used. I'm not opposed to that, but
Yeah.
we just haven't used that yet.
Got it. So, what do you think in terms of safeguards have to exist in place for law firms to scale like businesses without losing or compromising the soul of advocacy?
Each year, well, now they have 2-year renewals, but there's a renewal process in Arizona,
Yeah.
and you have to give them, a list of cases. How many Arizona plaintiffs do you represent? They haven't gotten to the point where how much your funding is, but they're
Yeah.
trying to regulate it where the funders don't have an oversized interest in any of the decisions that you make. You have to go through when we made the application. It's easier to adopt a child than it was to get the ABS license. I mean, they
Yeah.
go through criminal background, they go through everything. Then they have a hearing and they ask, because they've denied a lot of licenses. They don't want you to come in here and be just strictly a referral firm. They want to know how you're going to benefit the Arizona population. Even if you're doing a national practice, what's going to benefit the people in Arizona. So they're trying to watch it like that. And when you come up for renewal, there's been some ABSs that haven't gotten their renewal because
Yeah.
all they've done is, open up shop and send cases out, taking money and send cases out, which is
Yeah.
wasn't the purpose behind the ABS rule.
Yeah. Very, very interesting. Is there a risk, you think, that some people might get it wrong? Meaning they get into this, they partner with capital or marketing, and it's just purely for a financial, for a financial reason, right? And could that, because you know how it goes, somebody messes up and then it messes it up for everyone else.
Yeah.
Do you have a fear? Have you seen other people that have come into Arizona wanting to turn this into big business?
Well, that's happened all across the country without the ABS.
Yeah,
There are a lot of firms
good
that are,
point. Yeah.
very leveraged because they took in litigation finance. And if it's disguised as a debt,
Yeah.
then there's no ownership there. It's just a debt interest. So you've seen that outside of Arizona. The benefit of Arizona, for the funders is that you can share in the success. So they're going to be a little more, I think, calculated and a little more careful about how they invest the money because they can see a bigger back end versus
Hmm.
just the whatever interest rate they're charging.
Yeah.
If you have a funder who's your partner and they can get 30, 40, 50% of the fee versus just the interest off a loan, that's much more attractive to them.
Yeah.
So you have to be smart about litigations and which funders you use and
Yeah.
and the terms of the funding agreements, especially.
Well, I've been in this world for quite some time too, and I have a lot of experience and I've raised a lot of capital. And, business is business and, personalities and, you know, what the intentions are and how you start and where you end up. It's a moving target. So I have my own experiences, but I'm curious to know, when you have a partner, when your partner in a law firm is a capital group, are you locked in? What happens if, things don't go well? Just like in a partnership in a law firm, can you exit? Do you need to undo the law firm? Like I'm curious personally because I don't think this has happened yet that I'm aware of, but I'm sure there's a lot of people listening to this thinking, what happens if things don't go well?
Well, my particular situation, it's a non-recourse.
Mhm.
So, I won't be on the hook personally if
Mhm.
it goes south, which is why, they can take bigger chunks of the cases on the other side. I'm trying to phrase this as delicately as possible. I think like I used to consult with different litigation funders or people who did it, and they were willing to spend hundreds of millions of dollars a year. And when I was consulting with them and they said, "Oh, you have an ABS?" I said, "Yes." Well, we're willing to invest that money with you. I said, listen, that's great that you want to give me $100 million or $200 million. I don't know what I would do with that.
Yeah.
And there's a lot of firms that will take that money, which what you said before, there's firms who can tank a litigation because they've gotten funding. They go out and get 10,000 cases that stink, but then a defendant, it happened in Talc, J&J declaring bankruptcy because some highly funded law firms got tons of cases that didn't meet criteria. So that's the downside of all this, where funders are funding law firms that have no business being in mass torts. They look at it as a easy ticket to easy money, which is not the case. But what happens is they get all this money, they invest with marketers who are terrible, and those marketers flood the market with bad cases, which we're fighting every day, with because there's some unscrupulous funders, there's some unscrupulous marketers. So
Yeah.
it's still an area that is developing and evolving,
Yeah.
and we can see the problems as they arise, which is the massive amount of money going to the lower tier firms.
Yeah. So again, and that's very helpful, but more specifically, if you wanted to terminate your relationship with your capital partner in the ABS today, could you do that without, I understand it's non-recourse financing, or do they own a part of the firm and therefore, they stick around until all the cases resolve, they get their share, and then you kind of reset from there. Is that
Yeah,
how
I
it
mean
works?
they have an interest in the firm.
Yeah.
I have great capital partners, just the
Sure.
best.
Yeah.
Um,
I don't doubt your judgment. I just think people are listening and they're thinking, I've been approached by capital. Maybe I've been approached for debt. Maybe I should look at doing something similar to this because this, like you said, differently from raising debt, is a partnership. So they come in with a capital and you come in with your experience, with your relationship, with all of the wonderful skills that you have. And that could be a beautiful union, but it's not always a beautiful union. Sometimes people don't get along or don't see it the same way. So, what happens to this new firm that you've created when you have a capital partner that's interested today, maybe is not interested tomorrow? Like, does it, segue in different directions, or does it continue? Like, just wondering, as I think people are wondering, what would happen next?
that's a really good question. I don't think there's an exit clause in our agreements,
Okay.
but now, I would think, going forward, people should have those
Yeah.
exit clauses. We might have something in there if, we mutually decide to disband, then it would be a financial,
Hmm.
just a nightmare, with all the interests that are involved and the waterfalls and all that. We're in this for the long term. I know we are. Our main funder is looking at this long term, like a 30-year relationship. So, I mean, which begs the question, who are you going to get into bed with? And, you have to be really careful. Like your company is one of the best out there. So if people are looking for funding, they should come to you. Or they can get a hold of me and I'll tell them who to stay away from. Because there are definitely funders out there that you don't want to go to, who have onerous terms, who always have their hand in your pocket, who have these long tails where they continue to try to stick their hand in your pocket. So you have to be really careful on the front end of this, of who you're going to do business with. And as a funder, you got to be really careful which law firms you go to, because you could have a lower tier law firm who's going to get the minimum values on a case. And it's amazing to me that a lot of these financiers do not know who the good firms are. Like they go for the shiny object of the advertiser, whoever it might be, but they don't know, that it's the Laniers or the Seegers or, whoever it might be who are getting the best values, doing the best work. So it's a whole cottage industry now of who you picked and who you do business with. And that's going to end up being, everything's going to filter out itself, I think. But right now we're going through those growing pains with,
Mhm.
with the new frontier, as you called it.
Yeah, yeah. No, I appreciate you being so transparent because you're sharing things that I think a lot of people are curious about. This continues to be, a very sort of delicate topic. It used to be that litigation finance was taboo. If you said it, people looked at you the wrong way. And I've been doing this, I would say, sort of the initial waves of capital that came in back in 2010. And when you said litigation finance, people gave you the look. So it has morphed, it has transformed this space. And now it's become more mainstream, so people talk about it, but I cannot tell you because I'm on these calls with attorneys, very successful firms all over the country, some of the misconceptions about capital coming into the legal space and the intentions of capital about the legal space. And I do think that the truth is there is the fear that there is this like slippery slope between, allowing capital to come into scale versus it becoming just a business. And you lose the practice of law in that process. That's a real concern. And so, to your
Mhm.
point, who you work with if you decide to do this, and this is not for everyone, but for those who actually consider this seriously, who you work with, what kind of terms you accept, you have to really know and put the time,
Mhm.
to understand what you're getting yourself into because it is a long-term, engagement.
Without a doubt. I mean, firms used to and still use lines of credit for their to finance the litigation. So the fact that cases are now taking much longer
Yeah.
and you have this capital that you've borrowed that is going to sit around for 5, 6, 7 years, you might not want to risk, your line of credit going all the way up. So this is where the litigation finance is really helpful. It helps you to finance the cases, to stay afloat, to make the best decisions for your clients without having to worry about how you're going to finance the cases. Because I know there are firms out there who make settlement decisions based on their own financial
Needs.
situations or needs, exactly, which is direct conflict, to the ethics laws. So, if I can use capital without having to worry about, a line of credit or personal liability on it, I'll do a much better job for my clients because I can afford the best experts or I can litigate, I don't have to settle early. I don't have to be a pilgrim, an early settler type of thing. They allow us to be the best lawyers we can possibly be without having to worry about where the money is going to come from,
Mm-hmm.
which is, like I said, cases take so long now. I mean, we tried the first Vioxx case in 2005, and I settled the last one in like right before COVID in 2019. So those cases were around, 14, 15 years, some of them. So you can't have a line of credit which you're personally responsible for to go on that long. And this gives you, a weapon to use because we need to level the playing field against these massive corporations,
Yeah.
who have endless resources,
Mm-hmm.
countless firms, they always outman us, you
Mm-hmm.
know, and outspend us, but we're smarter. So
Yeah, I mean, when used with the right intent, it levels
exactly,
the playing field. And when not, and we have unfortunately seen this, it is a threat to the legal judgment.
exactly. And that's what the Chamber of Commerce or some of the,
Mhm.
the groups, tort reform groups will point to, litigation finances, making these cases more prevalent or more rampant, which I don't think is the case for most of the time, but that's what they harp on.
Yeah. Rick, am I right to think, because I've also done some work on the ABS and have some understanding of it, but is it and not full understanding, which is why I'm asking the question. Is it true that somebody can own the ABS 100% and then bring in partners, different partners, or I don't know if you call them partners, but you bring in different resources that you can then share fees with, but you can own the entity 100% and you can work with whoever you want and anytime you want without being bound to the partnership agreement and to, owning the firm 50-50, for example. Is that true? And would a capital partner even agree to that, for example, or do they need more skin in the game, as we call it?
Well, it depends on the capital partner.
Yeah.
Some just want, their interest, the loan interest.
Yeah.
Others want skin in the game.
Yeah.
I prefer ones that want skin in the game because they're looking at the merits of a case as much as we are. They're not looking at strictly numbers. Like we can get X amount of cases, say it was talc, we can get you get 5,000 cases, even if it's minimal value, because, 5,000 times X is going to be a lot more than what I'm trying to say is they'll get as many cases as possible, even if it's low value cases, because their ROI on their money
Yeah.
might be good. I
Yeah.
want capital partners who are going to look and say, these are the merits, get the good cases. Good cases are more valuable. You're not going to tank
Yeah,
a
you're
litigation.
taking an equal amount of risk, right?
Exactly. Exactly right. Yep.
And so they don't win unless you win, you don't win unless they win. I mean,
I
obviously.
prefer that.
Yeah. So there is a lot of firms, big firms that are very successful, from personal injury to asbestos to product liability, mass torts, all of the MDLs. Would it be smart or would it be advantageous to them to open an ABS in Arizona, separate and apart from their existing entity, and then partner with, say, capital or other resources that would advance, for example, another line or another practice area, or maybe a similar practice area, but just done with new resources that you can access through the ABS?
Well, you want me to encourage competition with me? Is that?
Well, I mean, I think people bring different things to the table, and I don't think you have competition, Rick. So
Thank
don't worry
you.
about that.
Well, I know what they ask you at these ABS hearings.
Yeah,
Like, why have you come to Arizona? What's the purpose of your practice? How is it going to benefit citizens in Arizona? Are you just looking at this to become take outside capital, become a national player versus what you can do in Arizona? So I mean, it's not as simple as, hey, I'm going to go open an ABS and then I'm going to partner with all these people. You have to have a mission statement, for lack of a better term. This is why we're doing it. When I had my initial hearing and I said, there's not a lot of mass tort firms in Arizona. There's not a lot of firms doing this area of law. I think it would benefit the citizens of Arizona to have this at their disposal or have it available when they didn't have it before. So you need a valid reason and mission when you come here to be able to open it, not just I want to avail myself of capital. I can't do it in New York or I can't do it in California.
sure.
You have to have a valid reason for doing it.
Like you have to run a real law firm, right?
Right.
And you have to be invested in wanting to help the Arizona citizens. So I totally understand. I mean, that makes a lot of
Yeah.
sense.
When we did our renewal hearing, the judge who was in charge said, after I made my presentation, he said, this is why we have the ABS rules for, you know, the way the Meadow Law Firm is handling itself. This is why we wanted to do this in the beginning, which was really nice.
Yeah, I know.
Um, we do have a number of Arizona clients and we're looking to do more work in Arizona. We do
Yeah.
pro bono work here. We donate to certain charities in the community. So we've made an impact
Yeah. Yeah. I get a lot of calls from California attorneys right now. You know,
because they can't share in fees.
can't share. So there's a lot of limitations. And then there's this fear that, personal injury firms are going to cease to exist in California should this Uber initiative pass. And there's this fear. So I'm getting calls about how should I diversify my business? Where else should I look? And so are you getting some of those calls and are you seeing an influx of California attorneys looking for ways to establish themselves like in other markets like Arizona?
Well, the California attorneys who we do work with now, California passed that law that says they can't share fees
Yeah.
with an ABS. So you try to figure, how you can make it work, whether it's separate retainers for the client or, different ways to try and make it work, or you just can't make it work, or,
Yeah.
you split your ABS off and become a regular law firm as well. So, as much progress as we make on the ABS front is as much, people trying to limit it. The California law, I think Illinois is looking at one, South Carolina might be looking at one, Colorado, they're trying to prevent, the ABSs from kind of taking over their practices, which I think is a restraint of trade, but that's just my opinion. I mean, every
Yeah.
other company, every other industry has financing.
Mhm.
When it comes to lawyers or plaintiff lawyers, we're always the target
Mhm.
for, tort reform. And, we've been the target tassel wearing loaf, trial lawyers for 50 years.
Right.
So
Right.
nothing's going to change there.
Yeah. And in that vein, Rick, you've lived through many eras of, for example, mass torts, because mass torts is sort of your domain. Not sort of, but it is. Asbestos, pharma, product liability, MDLs, right? What structural shifts are you seeing happening beneath the surface right now in mass torts?
I think this goes all the way back to the Vioxx days. When Vioxx was being negotiated, there
Mhm.
were a lot of firms that just were warehousing cases.
Yeah.
So we tried three cases, at the Lanier Law Firm. We won all three cases. But then when the settlement came around, it was a global settlement, meaning plaintiffs received the same amount for the same injuries, no matter who represented you. The
Mhm.
defendants started getting smarter after that, realizing that, hey, we don't have to pay, Joe Schmo from some small law firm in Arkansas the same amount of money that we pay Mark Lanier.
Yeah.
So they started changing their settlement strategies, going for inventory settlements, either picking off the low hanging fruit and going forward or trying to get a Lanier out or somebody like that. So
Mhm.
it's changed the way you look at litigations. Do you want to get in it on your own or do you want to co-counsel or send cases out, refer cases out? If you're smart and you're getting into torts, you'll associate with a firm, like Lanier or White's or somebody who you see who you're going to learn something from. Like I'm going to send you 100 cases, but I want to stay involved. I want to see how this sausage
Mhm.
is made. So I,
Mhm.
I see because of the way the defendants are now handling the cases, it's changing the way the plaintiffs are looking at the cases.
Right.
So it's kind of evolving from both sides of the V. So you got to be careful, like which cases you get into, how many you get, who you associate with. So whether there's going to be, Daubert issues, whether there's going to be 510K issues, there's a lot of issues that you look at before you would invest your own money in it. So that's what I see the most of
Yeah.
is firms picking and choosing which litigations and referrers picking and choosing which firms they want to send to. When I was consulting for one of the finance companies, they said, do you like this litigation? I said, no. They said, but there's an MDL. I'm like, I know there's an MDL. Look who's leading it. So we went online and looked at who's leading it. And the guy said, I never heard of these firms. I said, exactly. If there's not a name in there, there can be new names, but if there's not an established name in there, chances are the litigation's not good. So
Mhm.
just because there's an MDL or just because there's a lot of cases on something doesn't mean it's a good litigation.
Yeah.
Look at Tylenol, look at some of the other ones that have crashed and burned.
Yeah.
So, there's a lot that goes into which cases you want to pick.
Yeah.
So I think there's a lot more due diligence going into, who we're investing in or what torts and what firms we're investing in.
Yeah. Yeah, and look, traditionally, the law firms that do exclusively mass torts are very few because, and most of them go back to the tobacco, Viax, some really big like settlements that have been able to sustain them over the years so that they can continue doing this for 3, 5, 10 years. But again, that's very few firms around the country. Most firms that, at least in the last 10 years that I've seen getting into mass torts that are new, go in with so much excitement, leverage themselves, maybe bring in the wrong kind of capital, either as debt
Hmm.
or equity, and then they hope that that's their ticket to retirement. And
Hmm.
mass torts is not a straight line. And so if you're going to get involved in mass torts, one, you have to understand the case. You have to understand who's involved, to your point. And then you have to have other ways of generating income because you want to look at that. If you're referring it out, you want to look at that as just a passive investment, right?
Right.
And if you want to learn, to your point, and you're interested to learn the business of mass torts, then you use that as an opportunity to learn how the sausage is made. But outside of that, you have to have another thriving practice area that's generating income so that
Hmm.
you're not accumulating all this debt. And then your livelihood depends on whether or not these cases resolve. And unfortunately, I have seen a lot of firms fold under this kind of pressure. They made those decisions and they weren't able to survive. Talc is a great example. Even
Hmm.
Roundup, right? Depending on who you
Camp
were.
Lejeune could be one too.
Amplish, I hope not. Who knows, right? But I think it is an art. Like the practice law is an art. The
Hmm.
business of law is an art. And so the more you know, the more experience you have, the better you'll be, I think, to your point. So,
Yeah,
do you,
that's when you look at like some firms will invest in stage torts, like early stage,
yeah,
late stage.
yeah,
They don't look at the particular tort. They look at where it is.
yes,
Has there been bellwether trials? Is it ripe for settlement? Or is this the first case, there's been a recall or
yeah,
there's been, a verdict, from some remote jurisdiction, like, oh, there might be a case there. So you can look at it at stages. Is it the infancy stage? Are
yeah.
they actively litigating? Have they passed Daubert yet? Have you had bellwether trials? Mark just had the social media trial. That's the first one out of the gate.
Do you think that's the hottest mass tort right now, social media
Well, it did
overall?
garner a ton of press. We were involved in the video game addiction litigation. So the social media and the video games and all that online stuff, that is a hot area. I know a lot of firms that are looking at social media cases,
Yeah.
but I think the plaintiff pool there is basically endless.
Mhm.
What kid, whoever has kids knows how addicted the kids have become to all the social media and how it's changed how people live and how they act and what
Yeah.
they eat and how they dress. So it is a hot one, and there's a ton of firms, trying to get those
Interested.
cases.
Yeah.
There's only a couple I would send them to, starting with Mark, obviously. He tried that case and he has said it's the hardest case he's ever tried.
Really?
Yeah. I mean, the massive amount of money on the other side, I
Yeah.
mean, literally it's bottomless. They have as much money as they want.
Right.
They're the ones who are lobbying Congress for the exemptions.
Yeah.
So it is a hot litigation now. I would be careful about how much money I invested in it right now.
Okay. What would you recommend people invest if they had money to invest in mass torts? Where should they put their money?
Uh, I was talking to Chris Seeger about this a little while ago. It seems like there's a lull in the mass tort. I mean, people are looking at Olympus Scopes, which has a lot of potential. There's a couple of new litigations in the Roundup family,
Hmm.
of insecticides. We're doing a ton of sex abuse at Meadow. Not necessarily a mass tort, but there are a lot of, it's multi-plaintiff, not necessarily a mass tort, but we have a lot of sex abuse cases.
Yeah,
We brought on Lee Floyd. I don't know if you know her, out of Virginia. She's handling our mass tort, our sex abuse docket.
yeah,
Phenomenal lawyer, got a $360 million sex abuse verdict last year. So we're very active in that area. But that also is a real specialty. You can't just say, oh, I'm going to be a sex abuse lawyer.
right.
People have the misconception that mass torts is the gateway to riches.
Mhm.
Nobody hears about all the losses that have happened or all the cases that were thrown out, after 5 years, all the cases are dismissed, after millions and millions of dollars and thousands of hours have put into it.
Yeah.
People don't hear about that. They only hear about, the
The
big,
wins,
the
the
wins,
big
the big
verdicts.
verdicts and, the mass tort lawyer on his jet and all that. That's all they hear about. They don't hear about the losses.
Yeah,
We're
very
we're
true.
our own worst advocates.
Yeah, very true. Just one final question on capital, and we'll move on because I have some other questions on, there's a lot of other frontiers too. Do you think that the legal industry is headed for consolidation, for like these private equity roll-ups, just like the medicine and the dentistry world? Is that what the future looks like, you think?
I hope not. I really hope not. I mean, there's some of the big eight accounting firms have opened up ABSs here. I like to see the lawyers being lawyers and, capital being silent. If they're buying up firms and becoming, major partners in law firms, I think the practice will suffer because there'll be undue influence by non-lawyers. And that would be my biggest fear.
Yeah, yeah. Have you heard of the MSO? Because that's a new trend, the Management Services Organization, and how some firms are creating the MSOs to separate, from the practice of law and sort of figure out how to turn that into a money-making, machine. What are your thoughts about that?
I've heard of it. I haven't really looked at it,
Okay.
but I will.
But it's the latest trend.
No, I know. Yeah, I mean, you just go to any of the conferences, and you'll see the innovations.
Right, right. Well, I think the MSO is sort of, also riding the coattails of the AI because
Uh,
there's this idea that, okay, with AI, everything is going to shift and therefore this could be a great way of how you streamline all the services that are needed into a law firm and then monetize it in a more efficient way. And maybe you can do that, but it's very much in the infant stages, and I call it a trend because I think it's a trend until somebody can prove that it's a real business model and you can make money from it, and I'm yet to see it.
Well,
But
if
personally,
you look at,
yeah,
what's involved in a mass tort firm, you have your marketers, you have their intake, you have medical record acquisition, then you have the fact sheets. So, I mean, there is a growing need for something like an MSO, but you got to look at all the elements that go into it and pick the right. Again, you pick the right ones.
yeah,
If you pick it wrong, you're going to end up with malpractice on your hands.
yeah. So what do you think is going to happen with AI?
It's here to stay. I got to tell you, my Ruby hates that I use AI for certain things. She was a writer in Hollywood, so they all hate AI. But it's a necessary evil.
Yeah.
Mark teaches a whole section of it at the Trial Academy. He just tried a case where it involved AI.
Yeah.
Is I think he asked the question to Zuckerberg, is AI addictive or social media addictive? And if you plug it into any of the AIs, they'll say, yes, social media is addictive. So AI is a very, very useful tool. And if you're not using it, you're losing out.
Behind.
You're
Right.
you're behind. Yeah. I
Right.
mean, you need to check, citation check and do all that kind of stuff because there have been law firms that have gotten in trouble by submitting ghost sites or cases that don't even exist, or, they file a brief where they're treating a case that wasn't even mentioned in the opposing brief.
Yeah.
So you have to be really careful, but you can't ignore it. It's here to stay. And if you don't use it, you're definitely at a disadvantage.
Yeah. So what do you say to somebody that wants to go to law school that is looking at that as their future? Like, can somebody like you and I, who've been doing this for many years, give real advice to a young adult who is looking at law school? Because I think I'm concerned about what happens to the traditional apprenticeship model when young lawyers no longer learn through repetitive drafting and research, right? When they're not writing anymore. Like, what is the new age attorney going to look like, you think?
Well, I think it's one who's most skilled with AI for sure. Like I said, it's here to stay. So any
Yeah.
brief that you write is probably gone through one or two versions of AI.
Yeah.
We've gotten opposition briefs or motions that you can tell are AI written.
Yeah.
You have to be skilled in seeing that it's AI, checking that to make sure that everything's right. I mean, the human touch is still needed. And in our area, mass torts where trial work is necessary, or sex abuse where you have victims, AI can't give empathy, or AI can't, hold a hand. AI can't be the best representative or advocate. So, yeah, I mean, it's a useful tool, but it's not going to replace the human touch or the human brain.
Yeah. So you don't think that, I guess, because this is the point I've been making to young people that talk to me about going to law school, interns. I say, if you're a trial lawyer, you can't be replaced. But there is this little voice in the back of my head that says, what if, this is the human storytelling, and the ability to get in front of a jury to, advocate for somebody. Are those going to be, is that going to be preserved during this AI revolution that we're experiencing, you think?
Yeah, definitely. Definitely. You need, when you're on trial, you need that human touch, that human aspect. You paint your client, or you present your client as a human being who's been hurt or wronged. I mean, AI can't do that. You need the human emotion, the human compassion, the human empathy at trial. So it's not going to replace trial lawyers. Even brief writers, it'll make their job maybe easier and
Yeah.
more efficient, but it's not going to replace them.
Yeah, I mean, look, I like to believe that if the AI could be used to handle the mechanics, then maybe the focus becomes about philosophy and it becomes about psychology and persuasion, right? That you can actually focus on those skills more
Right.
instead of the parts of lawyering that are not fun for a lot of attorneys.
Yeah.
And so, yeah, maybe, I mean, there's always going to be a yin and a yang, I think, to everything. And the question becomes, where do you focus as an individual, as a young attorney, or even as a seasoned attorney as you transition into this next era? Because you have 10, 20, 30 more years to go. So, what kind of lawyer do you want to become in this next era?
I mean, even in litigation, the AI helps. Like if you're going to depose an expert and you feed in the expert report to AI, like what are the vulnerable areas?
Yeah.
AI might help you with that. It's not going to help you do the actual questioning, but it can give you areas or topics and actual questions. But you still need that human touch. You need to be able to read the witness,
Yeah.
to see, what moved them, what didn't move them, how
Yeah.
they're reacting to your questioning. So there's always going to be the need for the human touch.
For the human touch, no doubt. And I think that's going to be what people seek out the most because everything else is going to sound and
Yeah.
feel like a robot. So I agree with that. I have a question. If you could preserve one core principle of the plaintiff bar for the next 100 years, what would it be?
Uh, Preserve one,
One core principle of the plaintiff bar for the next 100 years. What would that core principle be?
the right to a jury trial.
Mm,
You
yes.
know, the what
Amen.
what's that?
Amen.
Yeah, what they're trying to do, with mass arbitrations and mandatory arbitrations is take away your right to a jury trial. And juries are the final arbiter, or the trial lawyers and juries are the last bastion of protection
Yeah.
for the community in general.
Yeah.
If you go all the way back, it's trial lawyers who got rid of flammable pajamas, Agent Orange, the Pinto, all these products that were hurting people. It was trial lawyers, tobacco, whatever it might be, it was trial lawyers that made the difference in society. And if you take away the right to a trial, you lose that leverage or you lose that ability to make products safe, to make the
Protect
environment safe.
the community.
Yeah.
Yes. Yeah.
Yeah. And that would be, the right to a trial by a jury of your peers, whether it's civil or criminal, is really, at the center of everything that we do.
I agree. I agree. That's a great answer. Great answer. Okay, lastly, I want to talk a little bit about, again, about you more personally, because
Okay.
you are an open book, and I love that about you. You've always been just so easy to talk to and to understand, and you've offered incredible advice to me over the years. It's just been such
Right back at you.
Yeah, it's been such a beautiful friendship. But this new sort of new stage where Ruby, your daughter, is joining the law firm, this adds a new layer to you, to what you're going to do. And you touched a little bit about this at the beginning, but what is it like to truly, because I have an 18-year-old that
I
is
know.
now in college, and it's different when you're living it, when you see your own child go into the world and you want to do all the right things. You want to help protect them and get them the right, opportunities, the right schooling. And, I had to figure it out.
Me
And
too.
and sometimes so did you. And sometimes I'm like, oh my gosh, am I doing too much to her own detriment? Are you navigating this like also as I am? Where is the line between helping, giving them the advantages that we didn't have, but also not letting that become the obstacle for how they figure it out and how they advance and how they, you know, understand how life works, if that makes sense.
Well, I'm lucky. Ruby is a very mature young woman, and she has given me the barriers or the guideposts to help her navigate through life and through the practice. It was her decision. I mean, I've always dreamed that she would want to become a lawyer because she would be amazing. But her direction for the last 10 years before this was in Hollywood, writing scripts. And I can appreciate that because I wanted to do something like that. So when she told me, she was thinking about taking the law boards and, this is a new phase of her life. Nothing could have made me happier. And she came here, and I'll tell you, Miranda, she's taken to this like nobody's business. She said, I found what I want to do and I found where I'm supposed to be. And every morning, I see her in the office. It's a whole
Light
different.
up like a Christmas tree.
Yeah, yeah, and I was out in Houston when I was talking to Mark, who's known Ruby since she was 6 or 7, and I told him she was joining the firm. I mean, he was maybe happier than I was, to see her come full circle
Yeah.
and to be able to set up a firm where she'll be able to take over and her future and her career will be set and she'll be able to employ Josh if she wants. There's nothing more rewarding than this.
Yeah. Well, I am so happy for you because you seem to be thriving. and seem to be so excited. And like I said, I pick up on this regeneration, reinvigoration of what the future is, looks like. And there's nothing better than that to be able to be so present and excited for the future. And again, very, very happy for you. I truly appreciate you being on this podcast
You
and
kidding me?
sharing so much of your wisdom and experience with me and the audience. I truly value you. So thank you so much.
Right back at you, Maria. You're the best.
Appreciate it. Well, thank you, Rick. And we will have more conversations on this podcast. It's not the last of the podcast we do together. So thanks again.
Good. Promise?
Promise.
Okay.